Welcome to this explainer. Today we're going to dive into a truly monumental piece of legal history, the landmark 1996 South African Constitutional Court case of Brink versus Kitshoff NO. We're going to see exactly how a brand new constitutional democracy wrestled with the stubborn ghosts of a very antiquated legal system.
Now, to really grasp the gravity of this case, we have to start with the human stakes. Picture this. It's 1994. Annette Brink has just lost her husband. Amidst all her grief, she's relying heavily on the financial security of a life insurance policy worth 2 million rand. Her husband had ceded this policy to her years prior. But, out of nowhere, the executor of her husband's estate steps in and literally demands the money.
So what exactly happens when a dusty old law, written in a vastly different era, collides head-on with a brand new constitution built on equality? Well, in 1994, South Africa had just adopted its interim constitution, which completely flipped the legal landscape on its head. But the specific law the executor used to demand Annette's money, that was written way back in 1943.
All right, let's take a quick look at our legal docket for today's explainer. First, we'll cover a widow's 2 million rand. Second, the strict referral hurdle. Third, a law out of time. Fourth, the equality clause strikes. And fifth, the final verdict.
Let's kick things off with Part 1, a widow's 2 million rand.
Back in 1989, Mr. Brink took out a life insurance policy valued at a massive 2 million rand. Just a year later, in 1990, he ceded that policy directly to his wife, Annette, making her the sole beneficiary. Tragically, on April 9, 1994, Mr. Brink passed away. But following his death, a huge problem surfaced. His estate was found to be insolvent, meaning his debts completely outweighed his assets.
And this is where Andrei Kitshoff enters the picture. He's the executor of the estate. Kitshoff sent out a standard notice to creditors regarding the insolvency, but then he turned his sights on Annette's life insurance payout. Relying on Section 44 of the Insurance Act of 1943, Kitshoff demanded that the insurance company pay almost the entirety of that 2 million rand straight into the insolvent estate. According to this old law, Annette was legally only allowed to keep a maximum of 30,000 rand. Think about that. Out of 2 million, she gets to keep just 30,000. Facing the complete devastation of her financial security, Annette decided she had to fight back.
Which brings us to Part 2, the strict referral hurdle.
So, under Section 102(1) of the new Constitution, lower courts essentially act as a very strict legal funnel. The president of the Constitutional Court, Justice Chaskalson, explained that a lower court can only bump a case up to the 11-judge Constitutional Court if it perfectly meets 3 prerequisites. First, the issue must fall under the exclusive jurisdiction of the Constitutional Court. Second, the constitutional issue actually has to be decisive for the case itself. And third, the referral has to be in the interests of justice.
But here's the catch. Annette's case hit a massive technical snag, and it revolves around a Latin term, concursus creditorum. Basically, it's a freezing of rights that happens in insolvency law to protect creditors. The problem for Annette? Well, Mr. Brink died, and the policy was ceded just before the new Constitution actually came into force in April 1994. Because the lower court failed to figure out the exact date this concourse of creditors began, the Constitutional Court couldn't be absolutely sure the new Constitution even applied. So technically speaking, the referral was completely flawed.
But despite this major technical failure, the Constitutional Court did something incredibly rare. They granted direct access. And why would they do that? Well, you have to remember that South Africa was in the middle of a massive, historic transition. The brand new constitution had just been enacted, and the court recognized that legal practitioners and lower courts were, frankly, still pretty confused by all the new procedures. Given the immense public importance of the issue, and to really serve the ends of justice and good government, the court decided they were going to hear the case anyway.
Let's move into Part 3, a law out of time. Now, what's really fascinating here is the bizarre historical irony of it all. When Section 44 of the Insurance Act was enacted back in 1943, the common law actually prohibited spouses from donating assets to one another. So, ironically, this law was originally designed to protect women. It created a legal carve-out for insurance policies so widows could at least get a small portion of the money. But jump forward to 1984, and the Matrimonial Property Act officially legalized spousal donations. Just like that, the original protective purpose of the law totally vanished. By the time we hit 1994, this outdated law had morphed from a shield into a weapon that actively and unfairly prejudiced married women.
And the legal imbalance here was just absolutely blatant. Take a look at this. Under Section 44, If a husband ceded a policy to his wife and his estate went insolvent, she was strictly capped at receiving only 30,000 rand. Or sometimes she'd get nothing at all, depending on the specific timeline. But flip that exact same scenario around. If a wife ceded a policy to her husband and her estate went insolvent, the law placed absolutely no limitation on him whatsoever. He got to keep all the money. I mean, imagine losing your spouse and having your entire financial security stripped away simply because you are a woman.
This leads us perfectly into Part 4, the Equality Clause strikes.
Justice O'Regan delivered an incredibly profound judgment focusing on Section 8 of the new Constitution, which is the Equality Clause. She stated, beautifully, that the Constitution is an emphatic renunciation of a past where inequality was systematically entrenched. She pointed out that while racial discrimination was undoubtedly the nation's most visible and horrific scar, other systemic patterns of disadvantage, particularly against women, were deeply woven into the social fabric. Section 44 clearly discriminated on the grounds of both sex and marital status, putting it in a direct, unignorable violation of the Equality Clause.
But, as you might know, legal rights aren't always absolute. Applying the Section 33 limitations test, the court had to figure out if this blatant discrimination could somehow be justified under the law. The executor argued that the law's purpose was actually just to protect creditors from fraud and collusion between spouses. Now, while Justice O'Regan agreed that protecting creditors is, for sure, a valid public purpose, she pointed out a massive, gaping logical flaw. There's absolutely no reason why fraud would only occur when husbands cede policies to wives, and not the exact reverse. Plus, the Insolvency Act already contained perfectly neutral mechanisms to prevent fraud without specifically targeting women. So, the limitation on Annette's rights? Absolutely not justifiable.
And finally, Part 5, the final verdict. Ultimately, the Constitutional Court delivered a massive, triumphant victory for Annette Brink and for married women across the entire country. The court unanimously declared subsections 1 and 2 of Section 44 of the Insurance Act totally invalid. The discriminatory law was officially struck down.
Now, you can't just strike down a law without causing some serious administrative chaos, right? So the court designed a really careful balancing act under Section 98(6) of the Constitution. First off, they backdated the invalidity to April 27, 1994, which was the exact day the new Constitution came into effect. This ensured women's rights were firmly protected from day one of the new democracy. However, just to ensure good government, they ordered that if an estate had already been completely finalized and paid out to creditors before this judgment, those past payments wouldn't be reversed. This was a super smart move. It prevented the total unraveling of countless completed estates, while still securing full justice for pending cases just like Annette's.
So, we'll end today's explainer with a pretty thought-provoking question. You know, the completely bizarre history of Section 44 shows us that legal context changes drastically over time. A law from 1943 that was actually meant to protect women somehow became a toxic, prejudicial weapon by 1994. It really forces us to ask how many other antiquated laws are out there just hiding in plain sight, waiting to be challenged by a modern constitution. The Brink versus Kitshoff case is a powerful, lasting reminder that the fight for equality requires constant vigilance to weed out the discrimination of the past. Thank you so much for joining me for this explainer, and definitely keep questioning the laws around you.